My name is Victoria Stumpf, and this is my statement of defense. My role is to be the junior legal officer at CDI Blumen. We'll start with a brief summary of the facts. Innsbruck Flores is the buyer, the seller is CDI Blumen, and together they signed a sales contract on the 25th of November 2025, which regards the sale of tulip bulbs. Now we'll present the law and source applied. Together there are 4 law cases and 4 academic sources. All of them are listed in here. The first major question entails, does actually Innsbruck Flores commit a fundamental breach by avoiding the sales contract as early as the 10th of January 2026? Yes. However, it's crucial to ask why this is important. Well, a party cannot avoid the contract unless the breach is proven to be fundamental. The fundamental breach will be switched to a non-fundamental one if the breaching party did not foresee the breach. It's in CDI's Blumen, therefore, best interest to prove that the breach of contract was fundamental. We move on to the foreseeability test and we ask 2 questions. Was it foreseeable? Was the breach foreseeable? And has CDI Blumen been substantially deprived? Well, in short, it was not foreseeable for Innsbruck to abandon the contract, and CDI Blumen has been deprived of receiving monetary compensation as well as they have lost a very important client. I would like to also mention here a case of National Plant and Equipment Pty Ltd, the Mandi P Heavy Equipment. The buyer, in short, has breached the contract by delaying payment. However, a mere delay alone does not amount to a fundamental breach under Article 25 of the CSG. And once more, it should be mentioned that Innsbruck Flores claims that CDI Blumen has committed a fundamental breach, but that goes directly against that case. With that, we'll move on to Article 72 of the CSG. Here it's stated that if prior to the date of the performance, it is clear that one of the parties will commit a fundamental breach, the other party may declare the contract voided. That is true. However, it's crucial to state that CDI Blumen, the seller, has never refused performance. Innsbruck was the one who has rejected CDI Blumen's attempts to cure the contract. To quote, temporary, they're unable to deliver the bulbs due to the fire disease, and they're simply uncertain, CDI Blumen is uncertain whenever delivery could take place, which is not a very strict declaration. It's not even a declaration of non-performance on the part of CDI Blumen. I would also like to mention another part here, that delivery date had not arrived yet. Delivery was due on the 1st of March. The buyer has avoided the contract on the 10th of January, which was merely a few months before performance was due. I would also like to cite another case here, which is the high original called Germany v. Italy case. In summary, a German retailer ordered shoes from an Italian company. The German buyer failed to pay. And the lack of payment equaled the high possibility, as the court said, for a future breach of contract. Once more, Innsbruck has not paid, which equals a high possibility of a future breach of contract only on their part. With that, we move on to another important question. Is CDI Blumen entitled to the full purchase price and damages? Well, the short answer is yes. However, it's important to ask 2 questions. Has the contractual breach caused actual damage? Yes. And has there been a causal relation between the breach of contract and the damages caused? Well, to answer to that would also be yes. And now we move further. What the buyer may do. They may exercise their rights or they may claim damages. In short, has Innsbruck Flores failed to perform the obligations? The buyer, yes, as they have refused to pay for the order. And because of that, CDI Blumen has resorted to the remedies of the buyer to simply pay the expected price, which is a remedy present in the Article 62 of the CISG. With that, I would also like to mention a case of the Korea Supreme Court 2025. Korean claimant entered into a contract with Russian buyer. The buyer refused to pay. In response to that, the buyer proposed several agreements. They were all refused by the Russian company. And it's very important, as it shows that CDI Blumen is entitled to claim the contract price once the buyer wrongfully refuses to pay or wrongfully abandons the contract. With that, we move on to seeking damages and remedies. To quote Bruno Zeller from Limitation on Claims with Article 74, a breach of contract within the CSG, unfortunately, does not give unlimited access to damages. In here, I would like to mention that it's important to ask whenever has there been a contractual breach caused by actual damage and was there a causal relationship. With that, we move on to another case of Brands International Corporation, which was a case of a retail distributor entering into a contract with a Canadian manufacturer. The Canadian company, in the end, was entitled to recover damages based on the breach, including a sum equal to loss, including loss of profit suffered by them, as well as the price for the never paid contract. In short, a seller harmed by the buyer's breach is entitled to recovery reflective of the contractual bargain. With that, we move on to a very specific word, reputational. CDA Blumen has included a word reputational when speaking of damages. However, Article 74, which is the most important provision which applies to most damages of the CISG, doesn't really classify reputational damages. It says it's a non-pecuniary loss, which takes only the form of a damage of goodwill, often called reputation of goods, or damage to the reputation of a firm in business. However, loss of goodwill is very difficult to prove and to measure. Which is why I would suggest changing the damage claim to regard simply the loss of profit, not the loss of reputation. In summary, in addition to interest and compensation for general damages resulting from the buyer's engagement with CDS Blumen competitor, the sum of €147,000 is a fair amount for Innsbruck to pay regarding the damages owed to CDA Blumen. With that, I would like to finish our presentation. Thank you so much.